Kia ora and welcome everyone. I'm Arie Moore, the founder and director of Reflective Construction Law. Relevantly for today, I'm also a teaching fellow here at the Victoria University of Wellington Law School, teaching a construction law paper this most recent trimester, and I'm looking forward to helping make the Master of Construction Law program a success next year. There's a great mix of people who've signed up for the webinar today, and that reflects the I think the interest and common arguments that occur around liquidated damages, especially when you're faced with delays. And it also indicates some of the uncertainties and misconceptions that can exist out there about what liquidated damages are. Today we're going to cover liquidated damages at a very high level, the grounds on which they can be challenged, and looking at it from the reverse to what's commonly used to challenge liquidated damages today, but in what situations could a principal challenge the amount of liquidated damages in a construction contract. And there's a little bit of a theme through all of that in these situations there's a bit of buyer's remorse on both sides. When contractors challenge liquidated damages, often that's because they signed up to something they didn't quite appreciate what it would mean. And the flip side today in our example is the same can occur for a principal. So liquidated damages are really a common feature in construction contracts and reflect that delays are all too often a feature of construction projects as well. You don't have to go too far in the media to see commentary about construction projects that are delayed, and the effects of that can be very significant for everyone in the industry. Liquidated damages, or LDs, which I might refer to them interchangeably today, are often challenged by contractors if they're late. And today we want to explore whether it's possible for a principal or client to challenge liquidated damages if they're in the situation where the damages don't cover their costs. So the starting point for liquidated damages is really that freedom of contract is one of the leading principles when it comes to liquidated damages. That is, parties are free to contract as they please, and the courts will look to enforce that bargain. Liquidated damages are essentially what the name suggests. They're an agreed amount of money that is payable for loss caused by a breach of contract. The amount payable does not have to be exactly the amount of the loss for delay, but usually and traditionally it should be linked to it. Courts have intervened and declined to enforce such clauses where they are determined to be penal rather than compensatory. So for a long time, the test in this space was whether the clause was penal in nature, in particular whether the amount reflected a genuine pre-estimate of loss, which was one of the tests put forward in Dunlop Pneumatic Tyre Co. and New Garage. The other important bit of background around liquidated damages is when we talk about them being damages, they're linked to a primary obligation. So the primary obligation in the construction sense is an obligation to complete by the due date for completion, and the secondary obligation flowing from that is that there is a liquidated damages amount paid per day of delay. And the benefit there is it also means you don't have to prove the actual loss and makes the administration of those provisions easier. In New Zealand, the Supreme Court has issued a judgment dealing with liquidated damages in 2020, which is the Hobson Street and Honeybees case. A lot of people, when we talk about the test that applies, that's really clarified the test that will apply in New Zealand, and as applies a very high threshold, and so the chance that liquidated damages will be unenforceable is very small in the traditional sense of contractors challenging what is taken to be an amount of damages. The Honeybees case was about leasing premises. So 127 Hobson Street leased premises for a childcare business to the Honeybees preschool. As part of that, they agreed to install a second lift in the building. Hobson Street was required to install the lift within 2 years and 7 months. And that was because the childcare centre, as you can imagine, would create significant pressure on lift access. The lift was not installed on time, and Honeybees used the clause to claim an indemnity from Hobson Street for its rent and outgoings, and that was in this collateral deed where there was an indemnity for all those obligations. 127 Hobson challenged that clause, arguing it was an unenforceable penalty. This went all the way through the courts and ended up in the Supreme Court. And in the Supreme Court, they clarified the position on unenforceable penalties, and now for a clause to be, or designed to secure performance to be an unenforceable penalty, you have to show that it's out of all proportion to the legitimate interests of the innocent party. And at that point, I just want to pause and talk a little bit about the Court of Appeal when approaching this legitimate interest test, which was first put forward in the Court of Appeal. As it approached, they said that determining whether a clause is an unenforceable penalty requires an objective analysis of the contract at the time it was formed and with reference to its terms and circumstances, including the broader commercial context. Legitimate interest is an interest in the performance of a primary obligation, and it can include direct and indirect loss affecting the overall commercial interests. But it does not include objectives unrelated to the performance interest. Now, they said the essential question in the Court of Appeal was whether the secondary obligation challenged as a penalty imposes a detriment on the promisor out of all proportion to the promisee's legitimate interests in performance of the primary obligation. That doesn't just have to be damages, that there are other legitimate interests the promisee might be concerned to protect, which can be commercial and non-commercial. The Court of Appeal also said that in that situation there should be a cross-check done with a punitive purpose test. So is the predominant purpose of the secondary obligation to punish the promisor rather than to protect the legitimate interests of the promisee? Now, that becomes relevant when we come to our factual framework here, because when you look at what the Supreme Court said, they said first that cross-check is not necessary or desirable, and that a clause stipulating the consequence for breach of a term of the contract will be an unenforceable penalty if the consequence is out of all proportion to the legitimate interests of the innocent party in performance of the primary obligation. And when they refer in that judgment to legitimate interests in performance, that includes an interest in enforcing performance or an appropriate alternative to performance. And relevantly, it'll be out of all proportion to the consequence can be fairly described as exorbitant when compared to those legitimate interests. So what's the position? Where does that leave us after Honeybees? So there is this legitimate interest test. The legitimate interest is a high test. It's not linked to a genuine pre-estimate of loss necessarily. Courts are open and acknowledge that there is a much wider recognition that completion on time in construction is an important factor, and so there is a legitimate interest in that. And they provided some context and said the test they articulate proceeds on the basis that a legitimate interest is in performance of the primary obligation, and that it can extend beyond being compensatory. Now we're going to consider a situation of what does that mean from a principal point of view? Can a principal challenge liquidated damages? And relevant to that, I started thinking about, well, does that mean the test to be whether there is still a detriment to the promisor? So here, in that using the Court of Appeals approach, a promisor is the contractor saying we will finish by this due date, and the promisee is the principal who gets the benefit of that and the liquidated damages if not. So does there have to be a detriment to the promisor, which is what the Court of Appeal said, that it's penal if there is a detriment out of all proportion to the legitimate interests? What if there's a benefit to the promisor as a result of the liquidated damages clause that can be said to be out of all proportion to the legitimate interests here? And the focus on liquidated damages being a penalty and unenforceable usually concerns where the amount stipulated as damages is higher than the actual loss, largely driven by that previous test being, is it a genuine pre-estimate of the losses? Although increasingly, the damages and how completion is dealt with is something parties do deal with in contracts, and often results in lower amounts of liquidated damages being agreed. And so principals may find themselves in a situation where the amount of liquidated damages does not adequately cover their losses incurred as a result of the breach by the contractor. So in developing the idea for this presentation, we wanted to really facilitate a discussion and look at, well, when in that situation could a principal challenge the amount of liquidated damages? And that's where I do note that the Supreme Court's test does shift from talking about detriment to the promisor to having a focus on whether the consequence is out of all proportion to the innocent party's legitimate interest. And yeah, in the case of liquidated damages, the innocent party is the principal. At paragraph 61, the court notes that while legitimate interest will not include objectives unrelated to their performance interest, it is wide and it is plain that deterring breach can be a legitimate objective of a clause. So that's still looking at the breach and deterring breach. If we turn now to sort of propose a fact scenario that will give a useful framework as we consider the situation when, in what situations could a principal challenge liquidated damages. So taking this as a hypothetical example, there's a contract for earthworks to be completed in a subdivision. The earthworks are due to be complete over 6 months, and there's a liquidated damages clause of $500 a day for 3 months, and then they get capped out. The principal's financing cost is actually $3,000 a day, and here, what if the contractor was delayed in completing earthworks by 18 months? Further, the other aspect of this fact scenario is that as a result of those extensive delays, the principal has had to refinance and incurred facility fees in addition to their interest costs and of refinancing fees. So can you have LDs and a penalty clause? Is this the case of Kimitos Holdings and Neil Silver Engineering? There was an amended construction contract for the development of residential land for subdivision, and that contained both liquidated damages and a penalty clause. Relevantly, the liquidated damages was stipulated as $4,200 per week, and then the contract also included a clause that said, in addition to any proven liquidated damages, the principal intends recovering the sum of $3,000 per 7-day week, or $450 per day, as a penalty for late completion of the works. And that'll be applied in addition to, is unrelated to, and is applied on top of liquidated damages. Now that's quite a simple fact scenario to me. The court held that second aspect was penal in nature, and was as an interim penalty in addition to the amount of liquidated damages. But importantly, the court has been willing to sever those two positions when exploring what may constitute liquidated damages. Further, then you consider what is the extent of potential LD's liability. In this case, the Mayor Councillors of Borough of Sydenham and Poor, the court found that there was a £1 liquidated damages sum was a penalty and therefore unenforceable. Now in that case, the council, call it the council because that's what we refer to here, the defendants contracted the plaintiff corporation, or the corporation, for the removal of night soil from the area, and there was a £1 sum payable as damages for each and every case of refusal or negligence in carrying out or fulfilment of the contract works. When they were carrying out the contract works, one night they left one of their carts on the wrong side of the road without lights and without any precaution against accidents. A young man on his bicycle collided with the cart and was killed, and his representative brought a claim against the council and contractors for negligence and claimed £200 in damages. Now there the court said it was a monstrous consequence and could not have been in the contemplation of the parties in making the contractor view that liability as within the stipulation of £1 damages for negligence in your performance of the contract. And that the misconduct was complained of was towards a third party. Now, relevantly, they said that the liquidated damages clause here did not apply because it did not fall within the ambit of the provision, and the amount was clearly inadequate to meet the damages, and therefore it was a penalty and unenforceable. The third aspect just to consider is whether liquidated damages clauses are exclusive all the time, and delay damages clauses can require liquidated and general damages. In New Zealand, we see that in the standard master build subcontract that provides an amount for liquidated damages under a head contract and extends the subcontractor providing an indemnity for any other costs associated with delay that may be incurred by the main contractor. And in this J.E. Hathaway case is a US case from the early 1900s. That, again, unsurprisingly confirms that is okay. That contract, there was $100 per day for late performance of its work, and all the owner's expenses for the inspection and superintendence of the works could be recovered as well. So one of the themes we're bringing through today is it does depend on what is in the contract, and how that has been agreed is relevant. You know, what is the scope of the liquidated damages clause that you are looking at? So circling back to then what does Honeybees say? The penalty doctrine at a high level is focused on whether the clause is a tool to punish. And the Supreme Court that was part of Honeybees also said the party's bargaining power is not irrelevant. So there's in a number of cases there's mention of unconscionability coming through in the reasoning where courts have found clauses are penalties. And the Supreme Court said that unconscionability is relevant in the sense that the impugned clause is viewed as an exploitation of an unequal bargaining position. So it's relevant to the court's inquiry into the nature and extent of the innocent party's interest in performance, but it doesn't replace the separate claim that you could bring around unconscionability. It's only relevant to the fact that looking at that balancing of power. So the bargaining power of the parties will be relevant to the court's inquiry as to the nature and extent of the party's interest in performance of the primary obligation. A court will presume commercial parties dealing with each other on equal terms are able to assess the appropriate proportion between the legitimate interest in performance of the primary obligation and the consequence contracted for on breach. However, whatever the relative bargaining positions of the parties, the issue for the court remains whether the consequences are out of all proportion to the innocent parties' breach legitimate interests in performance. So then what does that mean? Bringing all that back to our hypothetical example here. So to provide a bit more context to what we'd said, liquidated damages in the contract are 16.67% of the actual interest cost. After 18 months, liquidated damages would equate to $270,000. The actual financing interest would be $1.6 million. If there was a 3-month cap on liquidated damages, then the amount recovered would be even smaller. And the principal here could have incurred a further $250,000 of refinancing fees if the facilities were not able to be extended. In what situations could the principal there argue that LDs are actually a penalty and should be unenforceable so that it could look to recover its actual losses as general damages? So the agreed level of liquidated damages in the contract are a small fraction of the actual costs the principal will incur. You could ask, why would the principal agree to this? It might be there was only one contractor they were negotiating with, and it was a bottom line for the contractor. In that situation, the bargaining power is flipped between the parties and to what the traditional perception is in negotiations. Most people assume that contractors have to take whatever a principal's offering, but actually that can be flipped. Contractors are pretty staunch on taking lower liquidated damages where they can agree to that. It could also be that the principal was only considering small periods of delay. In the context of what was meant to be a 6-month project, delays of 1 to 2 months could be anticipated. Some people would say they would even be at the extreme length of what you would anticipate as a delay to that project. And so the principal may have agreed to the lower amount of liquidated damages given its legitimate interest in the project being completed was balanced against the loss for that shorter period. So an 18 months delay in that situation was not in either party's contemplation, and the principal may not have had a legitimate interest in agreeing to liquidated damages at that rate if the true extent of the delays were known. And so equally, the contractor is unlikely to foreshadow the extent of delays to the project if they thought it could take anywhere near that long. So it's analogous to the Borough of Tottenham case where the nature of some damages are not likely to be covered by the liquidated damages clause. So if we look at the example, the refinancing fees potentially are not delay-related costs. They're a separate type of damage that could be recovered anyway as general damages. And equally, applying the Supreme Court test of whether the damage is out of all proportion to the innocent party's legitimate interests and performance. I don't think the legitimate interest you could argue the legitimate interest of a principal to be under recovering $1.4 million of damages for 18 months of delay do not line up with what their rights could be. There are also some potential other bases that you could look to claim as well. So the doctrine of fundamental breach could be relevant in our example. Here, where to go from a 6-month contract program to taking 18 months goes beyond what was reasonable for any contractor to do. There are also, in the same vein, analogies to the prevention principle. So one party cannot take advantage of their wrong in seeking to enforce a position on the other party. That's a paraphrasing of the prevention principle. That again usually applies in the reverse, where a principal can't take advantage of causing the contractor to take longer and still enforce liquidated damages. The same principle on a first principles basis should apply where the contractor, if they were negligent or grossly negligent in how they perform the works, shouldn't be able to take advantage of a low level of liquidated damages to avoid the damages they have caused. Those are two other avenues to bring in relation to the delay at that extent does bring into question wider aspects. And the third is if you got to the point where you could terminate the contract, whether liquidated damages are subject to termination or not. The other aspect I'm going to talk about just for completeness, but liquidated damages clauses could be void for uncertainty, although that's very unlikely to be the case because in the New Zealand context, when you're writing about liquidated damages, they are generally well defined. Although you could see the situation where there's a construction contract that has a due date for completion of the 30th of November of 2024 and a contract period of 35 days, and assuming you sign that on the 1st of November, those two obligations are completely irreconcilable. So therefore, the due date for completion could be void for uncertainty. There's potential. That's the most likely situation I would have said that could apply using that argument, rather than focusing on bringing a claim that the liquidated damages amount themselves. So just bringing that all together on whether liquidated damages may be unenforceable due to claims by the principal. The context of legitimate interest at the time the bargain was agreed is important, and that's what that example's to bring out. You know, what was in both parties' contemplation at the time the bargain was agreed. Looking through it, the Supreme Court in Honeybees leaves open that the consideration of the penalty must be against the legitimate interest of the innocent party, changing their focus from the primary and secondary obligation a little bit, but especially taking away that focus on detriment and how they've put forward this test, which seems to leave a greater ability for principals to challenge the enforceability of liquidated damages clauses if the amount of liquidated damages are well below the actual damages that are incurred as a result of delay. But as with everything, legitimate interest is a high threshold, so it's not something that would succeed many times, but you can foresee some examples where that would. Of course, it is best to deal with this expressly, and you start to see that developing in some of the construction contracts that come through with scaled liquidated damages clauses. So, for example, starting a LD-free holiday for the first month, increasing to a certain amount for another month, up until after 3 or 4 months they get to a much higher level, or parties expressly agreeing that at certain points the termination provisions apply and then general damages will also apply. So there's always ways to talk about it, because challenging liquidated damages will be as unenforceable as a challenge because of the high threshold that the legitimate interest test does bring to considerations. That's the end of the presentation part of this webinar. We'll now have some time for questions. I don't know if you've had any, Carl? No questions yet? So if you have any, please do ask them. In my mind, it raises the question of was it an intention that the Supreme Court changed the focus from being a detriment on the promisee to the legitimate interests of the innocent party. I don't know if it was intentional or not, but it does make sense from a policy point of view. The same considerations should apply if the costs are much higher as if the actual costs are much lower.
We do have a question here from John Morton.
Hi, John.
Isn't part of the problem that a party in breach is relying on a limitation to its own advantage?
Yeah, I think that's a very good summary of the problem here. The liquidated damages clause is essentially a limitation, or an agreed limitation, and so then you have to go, at what point can the limitation clauses be challenged, and against the principle that generally courts don't like to intervene, you have to get to a really high threshold, either using a legitimate interest test or that you're looking at the doctrine of fundamental breach, for example, where courts have sort of said you can't fundamentally go away from if you're in fundamental breach of contract, you can't rely on exclusion clauses to avoid or limit liability for that breach. So I think there at a policy level is a threshold at which point those limitations won't apply, but it is a very high threshold to get to that point.
Cool, and we've got another question from Colin Orkiston. If the LDs are dependent on an extension of time, but the principal fails to process the EOTs, how does the contractor maintain the validity of the LDs?
Yeah, and that's getting to the sort of administration point of the contract. And at a simple level, if a contractor is entitled to an extension of time, the liquidated damages remain enforceable, and their relief is through the dispute process there. And I think that's a good point, that often people think that extension of time provisions and liquidated damages, or extension of time provisions there are to benefit the contractor, and so principals don't like to use it. But actually the reason we have extension of time provisions, and they are very broad in standard contracts now, is actually a benefit to the principal. They are there so that the principal can have the date extended and it remains a fixed due date for completion, so that liquidated damages still apply. If that doesn't, if there's a failure of the mechanism for granting an extension of time, then time's at large and you can only rely on general damages. So it is in the principal's interest that that mechanism works well, and that's something that is all too often avoided by principals because they don't like to extend time, but actually the consequences can be far worse if they don't. We'll bring it to a conclusion at that point, everyone. Thank you very much for coming along today. I think this is a, part of the construction law course here at Victoria University, and generally I think we want to be talking about what are the boundaries of certain things. There's a lot of common position that the Supreme Court's clarified it's the legitimate interest test, and so it doesn't necessarily have to be linked to a genuine pre-estimate of loss. You see a lot of contracts now expressly saying the parties agree that the amount of liquidated damages reflects the legitimate interests of the parties, but any court, while that will be informative to a court, they're not going to rely on that, and they're going to be looking at what was actually the legitimate interest at the time the parties entered the contract, and what is the position of the innocent party. So you really do need to think about the consequence of what you're signing up to at that time, and if being well advised and having good discussions between the parties is the best way to avoid disputes at the end of the day. Thank you all for coming, and we'll finish the webinar now.